Good morning, everybody, and I'd like to welcome members, the member in charge of the bill, Daniel Johnson, his officials, and those joining us online, the Economy, Energy and Fair Work Committee. This is the 30th meeting of 2020, and this is the second meeting that the committee has conducted remotely. And before I begin, I'd like to thank the broadcast team for making this possible on behalf of the committee. Now, I'd like you to turn to your agendas. Agenda item 1 is the decision on taking business in private. So our first item is to take the decision as to whether to have item 3 in private. Given the complexities of a group discussion over video conference, I'm assuming everyone agrees unless you say otherwise. So I'll just pause for any objections. Okay, we'll take that as agreed then. So our main item of business this morning is the continuation of our evidence taking on the protection of workers' retail and age-restricted goods Scotland Bill. So I'm pleased to welcome our witnesses. Daniel Johnson, MSP, member in charge of the bill. Andrew Milne is the head of Non-Government Bills Unit, and Kenny Tetkin, solicitor for the Scottish Parliament. This bill has been proceeding through our committee. We have taken evidence from a number of people, and this is our final session, taking evidence from the member who brought the bill forward. And I'd now like to invite Daniel to make a short opening statement.
Well, thank you very much for that introduction, Convener. And can I thank the committee for their diligent work in examining my bill, but also for resuming their work in doing so. Parliamentary time is an absolute premium, given that we're limited to these online sessions, so I'm truly grateful that the committee has prioritised examination of my bill in this way. I know I was struck, and I'm sure the committee was as well, by the powerful testimony given by both trade unions and the industry itself in the evidence that the committee took at the beginning of March. I think that they powerfully brought to life the very real issues that shop workers face in terms of abuse and violence, just through them doing their job and upholding the laws that we have created for them. Indeed, I think that evidence brought to life the very clear survey evidence that both industry and trade unions have to back this up. USDAW, the Shop Workers Union, in their survey estimate that 15 shop workers are assaulted every single day in Scotland. Every single respondent to the Scottish Grocers Federation Retail Crime Report stated that they had experienced incidents of abuse when a sale was refused on proof of age. And the Scottish Retail Consortium has published findings that the vast majority of workers do not believe that police take the problem as seriously as they should. In the context of the current crisis, I think these facts become even more stark. I think we've all become much more aware of just how vital the work that shop workers do is. Shop workers have very much been on the front line of the COVID-19 response and have assumed a key public health function that I don't think any of us could have foreseen. Unfortunately, in response to the restrictions in stores, a conspicuous minority of people have responded through swearing, abusing, and in the worst cases, threatening to cough and spit on retail workers. USDAW have reported a doubling of the rate of incidents of violence and abuse against shop workers through this period. So the primary objective of my bill is to respond and deal with these issues of abuse and violence. The general principles of my bill stem from these issues. Shop workers are required to uphold the law. They do so with a possible penalty of £5,000 fine or 3 months in prison if they fail to do so. Emergency workers and police officers have specific statutory offences of assault or obstruction or hindering, with penalties of £10,000 or a prison sentence. These offences could be argued to duplicate common law, but we deem them necessary given the public protection role that these critical workers undertake. It is also effective. Hundreds of people are convicted under emergency workers legislation every year. In carrying out ID checks, shop workers act as agents of the law, but it is with this function that also creates a key trigger point of violence and abuse against them. The statutory aggravation provision in my bill would provide a key recognition of this vital function and the seriousness with which the shop workers undertake it. In summary, There is a well-demonstrated issue that my bill seeks to address. It applies a legal approach that is well established elsewhere in law. I recognise and appreciate the various points of detail, but as the committee assesses the purposes and general principles of my bill for stage one, I hope it will agree with me that retail workers play a vital role in upholding the law and keeping us safe. And ensuring that they gain the protection that they deserve is an issue that I think deserves much more focus. I hope that my bill provides an opportunity for Parliament to potentially take steps towards that. I look forward to answering your questions.
Thank you, Daniel. What we're going to do now is we're going to move to each member in turn to put some questions to you to scrutinise the bill that we've seen so far. I will go back to you after they've asked their question, and then I will give the member a chance to ask any follow-up questions from you, and I'll move to each member in turn. So I'm going to ask you the first question just to set the context. You've set out a little bit about why you believe your bill is required, but much of the evidence we've received at the committee suggests that the real problem is not any gap in the existing criminal law, but rather it is to do with awareness, effective enforcement and reporting. So is this a reasonable suggestion? Can you respond to that comment?
I think there's an important principle at stake. When we ask people to uphold the law, I think they should have the protection of the law. And indeed, I would go further that we give them specific legal protections. And I think that the analogue of the Emergency Workers Act is a useful one. Prior to its introduction, there was a very serious issue of violent acts being perpetrated against first responders. The Emergency Workers Act was drawn up as a means of addressing that. And indeed, we heard many of the same arguments here, but by having that key specific protection, it has, I think, reduced that phenomenon. It's not one that we hear so much of in the media. Furthermore, it's legislation that is used. And the final point is this. There is a valid purpose and function of the law, one acknowledged most recently in Lord Bracadale's report on hate crime, to serve as a communication. And I think it is important that we have this key clarification that abusing retail workers is not acceptable, it is illegal. And furthermore, when they are asking for proof of age, they are acting as agents of the law. I think that's a critical point and one that needs recognition in law.
Can I just clarify then? Are you saying that you do believe there is a gap in the existing criminal law? Or are you agreeing with the suggestion that the gap, it's not the gap in the law, but it's the way it's enforced, the way it's promoted, the way it's understood?
I think that the key issue is that there isn't recognition in the law for the important legal function that retail workers are carrying out when they're upholding proof of age, and that's what this seeks to do. It also, I think, seeks to ensure, and this is what the statutory aggravation would do, that when people do commit those crimes, that is taken into account when they're sentenced. And at the very least, and as we heard from the Minister last week, if nothing else, what this would do is ensure that we have an accurate picture, because we would then gain the statistics. So whether we understand this as a gap in the law, or whether we look at this more as about ensuring that the law better reflects, I think, the important role, or simply that it's about ensuring that these issues, these crimes, are taken seriously and appropriately when they're sentenced, or simply just giving us more information. I think these are the issues that my bill seeks to address. Right.
Okay. Just finally, then, you keep using the word recognise, that it's about recognising. Now, the law isn't specifically there to recognise people's contributions or recognise the job they do, but it is there to recognise where a crime takes place or an offence takes place, and to deal with it adequately. Is that what you mean by recognise, or are you really talking about sending a clear message to people that you can't behave like this, and if you do, you'll be punished? Can you just make that clear?
I mean, I think it's both of those points. So, I mean, I think if you look at both the emergency workers legislation, or indeed if you look at Section 90 of the Police and Fire Reform Act, which is the section which creates the offence of assaulting or obstructing or hindering a police officer, what you see is a reflection in law of the important role that those people carry out, ensuring that that when those crimes are committed, they are assessed adequately. And I think there is also a function there in terms of communication and clarity, which stems from those bits of legislation. I mean, and that is the precedent I think that both of those pieces of legislation provide us.
Thank you, Daniel. Right, I'm now going to move to Alison Harris to ask a question. Alison, please.
Thank you. Good morning. The Minister suggested that a high-profile campaign may be a more effective way of raising awareness among retail workers and the public, highlighting that abuse towards workers is not acceptable and that they will be prosecuted under the current laws. So could I ask, do you think this would be an effective campaign, and would this make it have any benefit?
I think any effort to raise this issue would be welcome. But what I would note is this: on previous attempts to bring forward legislation such as this, there has been this argument made that a campaign should be formed, and simply nothing has happened. And I would also say that I don't think this is an either-or situation. I don't think my bill precludes an information campaign. Indeed, I would suggest that both an information campaign and the passing of my bill into law would greatly help. I would suggest that we should be doing both.
Thank you. Can I ask you now about data collection? So do you think that data collection is part of the problem, and would you agree, as it has been suggested, that other non-legislative measures like improved data collection would help to ensure that the police and other parts of the justice system have a clear understanding of the scale of the problem and treat it with the seriousness that it actually deserves? Would you agree with this?
I mean, I think there's various strands to what my bill may do, whether that's communication, whether it's legal, or whether that is data collection. I mean, I think there's a broader issue here in terms of the data that we have available in terms of policing policy and in terms of criminal justice. I think it's a source of frustration that we don't have insight. So, as Parliament considers the merits of my bill, there may well be other options which are open to government to collect this data. But in terms of the options that Parliament has in front of it, I think this is our one key step, which, if you're interested in improving data collection, this will do it. And indeed, that's a point that the Minister acknowledged last week.
Thank you.
Okay, thank you very much, Alison. Right, we're going to move to Richard Lyle next, please. Richard.
Thank you, Convener. Firstly, can I declare I'm a member of Cross-Party Group for Independent Convenience Stores, and previously, as people know, worked as a grocery manager in the grocery trade. Daniel, your bill will cover some but not all public-facing workers. Is it right to say that it will not cover bus and taxi drivers or refuse collectors? And what is the position in regards to relation to postal workers and other courier services?
Before I give you the full answer, I may well bring in Kenny and Andrew on this point, just in terms of the full technical detail. But let me also say, in terms of preamble, there is a balance to be struck. When you're bringing forward any bill, but particularly a member's bill, and that the resources that you have available are limited, and also given the Hugh Henry's attempt to bring forward legislation in 2010. one of the key criticisms of that was that it was too broad. And finally, I think that the observation that my bill starts from is that there is a key legal function that retail workers carry out in terms of upholding age restrictions. And indeed, that has increased because of the introduction of Challenge 25, which I think is welcome and important. So what I sought to do was start from that observation, that key legal function, and ensure that if people are carrying that out, and if they are exposed to risk because they're carrying out that function, that they have a degree of legal recognition and legal protection arising from that. Now, I think the other thing that, as we were preparing this bill, we were very aware of is that the nature of retail is changing. So that what we wanted to do was ensure that it wasn't just that people carrying out that function at a shop counter that were protected. It was also people who were involved with that transaction at any stage or however people may have been purchasing goods. And with the rise of online retail and people delivering, that the point at which that proof of age may be requested may not be at shop counter, but may well be at the doorstep. So we sought to include people such as delivery staff and indeed people delivering goods who may be asking for proof of age through the sale of that. We also extended it to people who are selling age-restricted goods and services, albeit not in a retail context, so that it will protect bar staff, it will protect people carrying out door-to-door sales, and so on. In drawing it up and having that focus on age restriction, we are not covering bus drivers or other public-facing workers. And indeed, it was a very specific criticism of Hugh Henry's bill that having that broad definition of public-facing worker meant that there was an issue in terms of clarity as to who would have protection or not. And I have sought to avoid that lack of clarity. And I mean, there is an issue here, and what I would genuinely hope is that this bill causes the Scottish Government to reflect about that broader issue of public-facing worker and who should have specific legal protections and of what sort, because I think that is a job much better suited to the much greater resources available to the Scottish Government to examine that broader issue. But I might just bring in Kenny or Andrew just to provide that greater clarification on precisely who is not and who is included in my bill from that legal perspective. Kenny, do you have?
Thank you. Perhaps we'll go to Andrew Milne first, and then right. Kenny.
Okay. I mean, I think I would say that obviously our role in the non-government bills unit is to deliver a legislative vehicle to reflect what the member's policy is. And Daniel's already explained what his policy starting point was. So that was always the focus was on retail workers. And that's what the bill focuses on. It was never about public-facing workers. And obviously it's for Mr. Johnson to explain why he made that particular choice. That's the basis on which we developed the bill. One of the challenges we faced in developing this bill was identifying as clearly as we reasonably could who it was covered and who wasn't. And this was it's not straightforward, but I think we are fairly clear that the bill covers all the people that Mr. Johnson was interested in protecting. We have tried to draw boundaries around that as clearly as we can, and we've set out in the policy memorandum, if you look in particular, paragraph 68, we've given as clear a list as we can of how the bill and its various provisions capture different groups of people in particular circumstances, and we've also put a list in there of some of the people who are not covered. So I think to pick up on particular the things that were mentioned in the question, I think Daniel's already covered this to some extent, but bus drivers, refuse collectors and postal workers are not covered. These are not people specifically doing retail work. We do have specific provision for delivery drivers in, for example, doing supermarket deliveries to people's doors, and that will include sometimes delivering goods which are age restricted. I hope that helps a bit to clarify. I mean, it's one of these things with legislation, you won't always get perfect definitions at every point of the boundaries that are defined. So at some point that will come down to interpretation and precedent, but we are confident, I think, that the bill provide as much clarity as we reasonably could.
Thank you. Kenny, do you have anything you want to add to that? Kenny Titkin?
No, I've got nothing to add.
Okay, thank you. Richard, do you want to ask anything else?
No, I think the question I always want to know is who was not covered. I think Daniel has explained. Thank you.
Thank you very much then. We'll move to Colin Beattie now, please. Colin.
Thank you, Convener. Daniel, I very much welcome you bringing forward this bill, because it does highlight an issue which, even in my constituency, I know to be a problem from time to time. There are certain aspects, however, which I have a wee bit of a concern about, and maybe you can help me with that. Existing offences, for example, already allow for the prosecution of a person who assaults, threatens or abuses another. Now, these offences, where appropriate, can be prosecuted under solemn procedure, which allows for higher sentences than those available under the bill. Why are we not relying on the existing offences when that retail worker is assaulted, threatened or abused?
Well, I think there are two things to say about that. First of all, that is a provision, and that is virtually identical to what's in both the emergency workers legislation and indeed the Police and Fire Reform Act. So, from that perspective, those bits of legislation have not created a problem. Furthermore, it is absolutely up to the Crown Office to decide, what charges to bring forward. And indeed, if they think that warrants that, they can bring charges under different legislation, different law, if they feel that the higher penalties would better reflect the crime. That is part and parcel of our legal system. So my bill does not preclude crimes being brought forward under different pieces of law, and indeed it reflects, I think, what is already and was already acknowledged to be a useful legal provision, both in terms of the Emergency Workers Act and the Police and Fire Reform Act, Section 90.
In your opening remarks, you did mention about the fact that, or your belief that the police did not necessarily respond as quickly or with as much priority as they should in terms of the existing legislation. If we put this bill in place, what is going to compel the police to respond more quickly and with more urgency?
I think there's various strands to that. I think first and foremost, the simple act of new legislation, both in terms of the discussion and discourse that happens preceding it, and indeed the introduction of new laws, will require the police to re-examine their policies as a result of it. That is what they have to do whenever new legislation is passed. And furthermore, I would point to the fact that the Emergency Workers Bill is a piece of legislation that is used. At the moment, it's used between sort of 200 and 300 times a year on average over the last few years. So in terms of the efficacy, I think that acts as a useful analogue for what this bill may do and how useful it may prove to be.
I'm still a wee bit concerned here that if under the existing system we are not giving police to respond, why are they going to suddenly change because there is an update or a refurbishment or whatever of the legislation around this? And I'm trying to think of practicalities here, because we all know that police priorities and so forth, and the call on police time. How do we get them to treat this as a priority without needing to go through a whole slew of new legislation?
Well, first of all, I wouldn't describe my bill as a slew of legislation. And indeed, I think through a few parliamentary votes, we may well be able to provide absolutely the focus and priority on this issue that's needed. And look, I think in a sense, Mr. Beattie, you're highlighting on a dilemma that we have within our system. We have a system whereby the police cannot be directed by politicians or by ministers, and that is absolutely correct. What we can do is pass laws, through passing those laws, hopefully we communicate to the public, we communicate our priorities, and we also ensure that the law operates in a way that we think reflects the seriousness of the crimes that are perpetrated, and indeed reflects the duties and obligations that we place on these people. So absolutely, it does not necessarily automatically mean that there will be a kind of an overnight change in the way that the police do or do not respond to certain crimes. But I think it's certainly in terms of the options we have available to us, the powers that we have as parliamentarians, as a parliament, allows us to state what we think the priorities are and what we think the law should do and how it should deal with people committing these sorts of offences.
You seem to be indicating that bringing this new bill in would highlight to the police the priority needed in terms of retail workers. If that's the purpose, surely a high-profile campaign such as we talked about before would have the same impact in bringing it to the front of police priorities.
Well, first of all, I don't think it's either or, as I said to Alison Harris. I would urge both of those things to happen. I would urge Parliament to pass my bill, and I would urge the government to bring forward a clear communication plan. But it's not purely about communication. I think the statutory aggravation is also an important element in ensuring that when people do commit these crimes, that when they are sentenced, that sentence it does reflect the seriousness of that crime. And that's not to say that couldn't happen or can't happen, but it ensures that it will and does happen in the future. So it's not simply about communication. It's not simply about trying to reprioritize these things. It's not simply about a statement. It is also about ensuring that when those crimes are prosecuted, when people are found guilty, that those penalties reflect the seriousness of the crime, which, after all, these are crimes which are being committed against people who are simply trying to do their job and uphold the law.
Thank you, Daniel. Thank you, Colin. Right, I'm going to move to my deputy convener now. Willie Coffey, please. Willie.
Thanks very much, convener, and good morning, Daniel. On the matter of obstructing and hindering, there was quite a lot of discussion about that at the last committee meeting, Daniel, and we heard evidence that this is already covered in law when it's accompanied by threatening and abusive behaviour and so on, and that the punishments are already more severe than those proposed in the bill. So it was felt by some that your bill, if it proceeded unaltered, would in effect criminalise what some people said amounted to irritating or nuisance behaviour, perhaps by children. Could you set out what your position is on this in response to what I've said, and maybe give us an indication if you might consider changing this aspect of your bill to try and get wider support for it? Because I think the Minister said she was open to looking and listening to issues if the bill goes forward. So I'd be obliged if you would give us your perspective on this important issue that was discussed at the committee. So
if I can perhaps begin by just setting out kind of the purpose and why we included this. So I think that there is a scenario and a situation. I think a lot of people in retail who work behind shop counters recognise where a situation occurs and it escalates from seemingly quite kind of innocuous beginnings, where people are refused a sale because they can't produce ID or refuse to. And it doesn't immediately start with violence. It doesn't even necessarily immediately start with abuse, but it starts with people saying things such as, I'm not moving from this spot until you sell me that bottle of whatever it may be, or that packet of whatever it may be. And I think what I was attempting to do is reflect that when shop workers are asking for proof of age, they are carrying out actually quite an important, serious, indeed a solemn act of upholding the law. And when you interrupt that process, when you obstruct or hinder it, I think you're doing something quite serious. I was also attempting to capture a set of behaviours which I think most people would agree are wrong, and that can escalate to something much more serious, and therefore draw kind of a clear early line at which people trip over into doing something that is wrong and illegal. And indeed, I think this in some ways reflects things. It's a crime to waste police time, for example. Because when police are carrying out their investigations, inquiries, their duties, if you do things which waste their time, that is quite a serious thing to do. So it's a similar kind of logic that I was attempting to apply here. However, that being said, I recognise that as it's currently framed, it is quite broad. The obstructions are set out are applied to the broad duties of a retail worker, not just carrying out age restrictions. And therefore, I do recognise the issues which have been arisen. So, and I think this is exactly the sort of issue which I think would be extremely useful to examine at stage 2. I'm very open to either amending that, restricting the scope of it, altering it. Indeed, I don't believe that part of my bill is central or critical or as important as the offence. And I think the really critical point is the aggravation, which I think acknowledges and reflects the important legal role and duty that retail workers carry out when asking for proof of age. I hope that it explains both the purposes and my position on that part of my bill.
That's really very welcome, Daniel, and I don't have any other questions, convener, so I'm happy to let other members come in now. Thank you very much.
Thank you, Willie. Can I move to Andy Whiteman now, please? Andy.
Thank you very much, convener. Just following on from Willie Coffey's question there, I mean, you acknowledge in your bill that the obstructing and hindering is part of the overall offence created in the bill, and it's not restricted in any way or tied to the question of upholding statutory sale restrictions. I mean, in your policy memorandum, in paragraph 64, you say that you don't think there should be a physical element necessarily present before an offence of obstructing and hindering could be advanced, but that a person refusing to move on in a queue may be caught by this. And you then say another example might be where a retail worker is using equipment, for example, a shopping trolley, and a customer refuses to get out of the way. I mean, in what world should someone obstructing a shop worker with a trolley mean a criminal conviction?
Well, I think the key point here is that such an obstruction would have to have clear intent, that what the person is doing when they're obstructing in that way is to disrupt and prevent that person from carrying out their duties and their work as a retail worker. So it couldn't be simply an inadvertent or unintentional obstruction. That wouldn't trip over that threshold. And secondly, there would need to be that clear intent. And this is logic which draws on from emergency workers legislation and Section 90 of the Police and Fire Reform Act, where obstructing someone from carrying out their duties. Now, I think this is, but where I think there is reason for debate, and I think also a need for focus at stage 2. I think the points about whether or not the duties and role of a retail worker in the broad sense, in terms of their full role, not simply just in terms of carrying out age restriction, whether that's sufficiently serious to create a criminal offence, and that is an issue which I concede, and I accept that in that regard, these provisions are possibly set out more broadly than I might have wished. I mean, in all reality, the resources that you have available to you as a member bringing forward legislation, and the non-governmental bills unit do a fantastic job, but they are trying to help a number of members simultaneously. If I was a minister sitting in front of you and I had the full resources of the Scottish Government at my disposal, I would much prefer to have a much broader set of proposals looking at how we ensure that the seriousness of upholding the law and ensuring that people comply with that and recognise that legal obligation and duty that we place on new workers. I would have a much fuller set of proposals. I brought forward this obstruction because of the precedent that was there, but I think there are quite probably issues, but those are issues that I'm more than happy to examine through stage 2 and through stage 3 of this bill, should Parliament give me the opportunity to do that.
Okay, thanks. There's no need to apologise for the bill. We're obviously scrutinising the bill as we would scrutinise any bill. No, that's helpful. And I think you're right. I mean, I think there has been discussion around this, and I think there's probably a way through that. I just want to move on to the question, to section 3, the defence to charge of obstructing or hindering. I mean, this says that there's a defence to this where the behaviour was in the particular circumstances reasonable. Can you say anything about how you would anticipate reasonable?
Yes, and I assume that you're interested in why we introduced the reasonable defence for the obstruction part and not the other. Is that? Would you like me to explain that as well?
Well, that's a question the Scottish Government
raised. One thing at a time. Okay.
I'm focusing on the.
So, I think when it comes to obstruction or hindering, I think you can well understand a situation where a retail worker is carrying out their duties. And is, for example, walking on a path that may lead them to fall through a trapdoor in the floor that they've not seen, and therefore somebody who is literally putting a trolley in their way or standing in their way is therefore acting in a very reasonable way, and a way that doesn't necessarily cause them immediate harm, but does prevent them from falling through that trapdoor. And I think there are a number of other scenarios like that where potentially obstructing or hindering a person may prevent other harms from happening and therefore is reasonable.
Okay, thanks. I mean, you raised yourself the question of the lack of a reasonableness defence to the abuse and threatening, which the Scottish Government have raised. I don't have time to get into that, but if we have time at the end of the meeting, I'd like to raise that with you. I just want to conclude on one point in terms of my questions. Police Scotland have questioned the validity of the comparisons between obstructing and hindering retail workers on the one hand and emergency workers on the other, given that emergency workers are very clearly, in many cases, trying to save lives, and therefore it could be life critical. I mean, do you accept that that's a comparison, if you like, that's not perhaps as valid as you appear to have made out?
Well, look, I mean, I think it's an important comparison. Obviously, my bill draws on the logic and measures of the emergency workers fairly heavily. I mean, what I would say is that, I mean, absolutely, the matters that emergency workers deal with are, have a seriousness that they very often concern matters of life and limb, immediate matters of life and limb, that perhaps the duties of retail workers do not. But by the same token, not everything that an emergency worker does will be concerned that, and the emergency workers legislation doesn't draw the distinction between when an emergency worker is carrying out those immediate issues of life and limb, or perhaps other duties such as public information or what have you. And likewise, I mean, what I would say is that when you look at the broader reasons that we have these age restrictions, death from tobacco and alcohol are very significant causes of death in Scotland. We have these age restrictions because ultimately they do save lives by imposing them, and that's not the same immediate, matters of life and limb that other emergency workers are carrying out. But I think it's wrong to say that they're not matters of life and limb at all. So I think there is a discussion to be had as to whether or not obstructing a retail worker is as serious as obstructing an emergency worker. And I fully accept that they are not necessarily the same orders of magnitude, but I think there is clearly a parallel. I mean, clearly retail workers are upholding the law. Clearly the upholding those laws is important in terms of protecting well-being in the broad sense. And so therefore I think it's a valid argument to have, and I think it's one which I hope we can have further stages of my bill, and one that I'm happy to engage in.
Okay, thank you, Andy. Thank you, Daniel. Right, can I move to Rhoda Grant now, please? Rhoda.
Good morning. The committee's had very clear evidence that enforcing legal restrictions on sales can trigger abusive behaviour, and indeed I think we've all witnessed this, especially more recently when retail workers are trying to enforce things like social distancing and to stop panic buying. So I would like to ask, how do you think an aggravation would address this kind of behaviour?
So, I mean, I think the aggravation does two things. First of all, and most importantly, at the point of sentencing, ensures that when people are charged and found guilty of these offences, that the sentencing, I think, reflects that. And then I think, secondly, it does, I think, emphasise the point of just how important it is that these enforcements of age restrictions are carried out by retail staff. And indeed, I think one point has been made to me by people working in the sector and by the trade unions, is that if nothing else, if this bill enabled there to be a very clear sign at the shop counter saying that it is an offence to abuse or assault a retail worker, and there is a statutory aggravation if you do that while I'm carrying out my responsibilities and legal duties in terms of age restriction, that would be useful in and of itself. Having that clear law, being able to communicate that and state that to customers. But I think the aggravation point, I think would make a really real difference in terms of sentencing and emphasising the seriousness of those issues and those crimes.
Okay. Your bill very clearly covers age-restricted products and the like, but as I said in my original question, we've all witnessed abuse coming to retail workers in the current situation where they're really trying to keep everyone safe and make sure that there's enough stocks for everybody to get what they need. Does your bill cover that kind of behaviour, or would it be possible to amend it to cover that kind of behaviour?
So the statutory offence that's created covers assault and abuse in broad terms. That's not specifically related to age-restricted items at all. So in that sense, it would address in part. But I mean, I think that this is a really important question. I think that has arisen in recent weeks and months. I mean, I think we've all seen in supermarkets retail workers enforcing social distancing. I've been struck by at my local supermarket retail workers with markings on the floor and advising people where to stand, and indeed controlling the flow of customers into stores. I mean, there's a clear public health function that is being carried out, and one that is being again required by government, if not necessarily by law. And I think that my bill, through coincidence, I think potentially affords us the possibility of looking at whether or not there are further protections in light of the current context, or certainly more broadly when there are situations such as the one we're currently in, where we ask retail workers to carry out particular functions, where the government sets down particular regulations that it seeks them to uphold, whether or not there is some reflection that could be given in law. And indeed, the parliamentary procedure through stage 2 certainly affords us the ability to take further evidence. Certainly stage 2 and stage 3 would enable amendments to come forward that may examine that in more detail, and I would really welcome that. I don't think we can divorce my bill in terms of the broad issues it seeks to raise from the current circumstances that we all find ourselves in right now.
Yes, when you brought forward the bill, you couldn't have possibly imagined the current circumstances we find ourselves in, but I think it was right to look at protecting workers in that situation. I think the population as a whole now applaud our retail workers and are much more aware of the job they do. Do you think this bill would send a signal to retail workers about the value that is placed on them? We've talked about paid workers having to bear the brunt of this crisis. Do you think that would send a clear signal to them that we value them and that we will take steps to protect them when they're in the front line?
Yes, and I think it would send that signal, and I think it's a really important one. Over recent years, and from governments of various hues and stripes, we've seen a tendency to think that we can essentially introduce public policy through buttons on the till. Challenge 25 most conspicuously, but things like the bag charge and the deposit return scheme, all of which I think are really useful and valuable propositions. But there has been that sense that essentially you can do these things and there's no cost to government and it will get taken care of. But when retail workers are carrying out these things, they're carrying out important public functions, and I think it's really important that we ensure that retail workers know that they're valued, and I think there's no better way of doing that than providing the recognition in law of the duties, in particular, age restriction duties that we ask them to carry out. But I think there is a reassessment going on about the value of all sorts of work, not just retail work, but I think that is an important thing for us to all reflect on at this time.
Thank you.
Thank you, Rhoda, and thank you, Daniel. Can I move to Gordon MacDonald now, please? Gordon.
Thank you, convener. And can I remind people that I am the convener of the cross-party group on independent convenience stores. And I agree, Daniel, that we do need a culture change, but we also need to ensure that any changes to the law are the correct ones. Colin Beattie has already highlighted that existing offences can be prosecuted under solemn procedure and so may attract higher sentences. In answer to Rhoda, you said that the aggravation would make a real difference in terms of sentencing. Yet your policy memorandum at paragraph 53 highlights that the aggravation in the bill would not increase the level of sentence available to a summary court. So could you maybe highlight what would be the proposed aggravation add to existing provisions?
So what a statutory aggravation does is it doesn't necessarily increase the sentence available to the courts, but what it does is require sentences to take into account the behaviours or circumstances set out in the statutory aggravation when they're passing on sentencing. So I think I'll pass on to Andrew in a moment. But I think the other thing that I would add is, and I've said it before, is that this is very much the same situation that these crimes, when they're committed against emergency workers and the police, may find themselves. Those bits of legislation likewise are carried out under summary procedure. There may well be crimes available to prosecutors that carry a heavier sentence, and indeed prosecutors, when they're bringing forward those charges, may well choose to use other bits of legislation to prosecute people if that's what they deem necessary. But I'll bring Andrew in to provide further explanation in terms of how statutory aggravations work and indeed the comparisons with other areas of law. Andrew.
Thank you, Daniel. Yes, I was just going to say that the way the bill works is based on a lot of precedent we've already got in existing legislation. And in particular, whenever you create a criminal offence, you have to specify what the maximum penalty available to the court would be. But of course, the average or the typical sentence is well below the maximum. I don't have exact figures for this, but I think at least in some cases there's evidence that the average sentence is roughly half the maximum. So obviously if you increase the maximum, you increase the average sentence as well. But a court will always exercise discretion according to the facts and circumstances. So the point about an aggravation is to sort of nudge the court to apply a higher penalty than it otherwise might do because of a particular factor that's been featured in that particular case. So usually there's plenty of headroom because the sentence that the court would normally be applying in that case is going to be well below the maximum in most circumstances anyway. So the court can add a little bit on because it's aggravated. And therefore, by adding an aggravation, the fact that you're not increasing the maximum penalty doesn't really matter very much in most cases. And in terms of the way this particular bill sets out procedure for aggravation is very much modelled on all the existing statutory aggravation legislation that's already been put in place by the Parliament over a number of years. So the fact, for example, that the court is not required to increase the sentence, but it does have to justify if it's not going to do it. Those sorts of features of the bill are very much modelled on what existing legislation does in these circumstances. So it's simply adding another statutory aggravation very much in line with what's already there. I hope that helps a little bit.
Yes, it does. Thank you very much, Andrew. In order to move this forward and gain government support, it's been suggested that an alternative legislative approach would be to create a new statutory aggravation that can be applied to existing offences. Would you see this as a possible way forward, especially if it was focused on situations where a retail worker is seeking to enforce an age restriction?
Look, first of all, I'll very happy to examine any alternative approaches, in particular if that secures the broad support of Parliament. And I will again bring Andrew in on this point, because I think what's important to note here is this was an approach that we looked at quite thoroughly in terms of drafting the bill. And the reason that we rejected it was really one of precision. In that, much like you'll see in my bill, there's quite a kind of a reasonable amount of space given to trying to define precisely what a retail worker is. If you were taking that approach, you need to spend quite a lot of time actually deciding, well, what offences is it that you would want to attach the aggravation to? I mean, are you saying that it's any offence committed against a retail worker could be aggravated in such a way, or is it particular offences? And I think that then becomes quite a complex picture. We felt that it was simpler to create a straightforward statutory offence so that you had the clarity of precisely what it is and who it attaches to, and then have an aggravation that layered on top of that to reflect the seriousness of those offences when they're in connection with carrying out age restriction. But I'll hand over to Andrew, who I think can probably provide kind of a better technical explanation to what I've just described.
It might actually be more one for Kenny. He might be better placed in this particular instance, I think, to answer the question.
Yes, I'm happy to respond. Yes, I think it's just what the member was saying, that we're keen to get clarity in the law. if the member wishes to look at that in the future, we can certainly look at how we might apply an aggravation to more offences. But I think, for our concern, we were trying to be as specific as possible to allow people who are accused of offences to know what the offence and what the sentence might be should they carry out that offence. So we thought that it would give people foreseeability and clarity as to what is expected of them in the law.
Okay, thanks very much.
Okay, thank you, Gordon. If there's no further questions on that area, I'll move to Dean Lockhart, please. Dean?
Thank you, Convener, and good morning to Daniel Johnson and our other guests. In evidence given to the committee by the retail sector, we were told that problems faced by retail workers here in Scotland are similar to the problems faced by
the sound is breaking up for me. I didn't hear that question. I don't know if Dean is still speaking.
Yes, I lost Dean as well. Dean, are you still with us? I think we may have lost him.
Good morning. Good morning, Convener. Sorry, I seem to have dropped out.
Right. Again.
Yeah, we have lost Dean temporarily, so we'll try and come back to him. Oh, he's reappeared. Dean, can you hear me? Are you still with us? You want to try again?
Convener, apologies, the system dropped out for a second. I was wanting to ask about the protection available to retail workers elsewhere in the UK, because when we heard evidence from the retail sector at the committee, we heard that the problems faced by retail workers in Scotland are very similar to the problems elsewhere in the UK, for example, as threat. So I wondered if Daniel Johnson or the other witnesses this morning had looked at the protection available in legislation elsewhere in the UK, and whether there are additional enhanced protections available for retail workers elsewhere, so that we can have a look at that legislation or additional protection and compare it to the proposed legislation in front of us.
My understanding is that, first of all, these issues are ones that are faced right the way across the United Kingdom. But like the situation faced by retail workers in Scotland, that there is not any particular additional legal protections that retail workers enjoy that Scottish retail workers do. I mean, I may just bring Kenny in on this point, who may be able to provide insight into whether there is other legislation in the UK that may. But what I would do is say that this is an issue that has arisen in Parliament in Westminster. There was, with the passage of the Offensive Weapons Bill in the last Parliament, attempts by David Hanson to introduce amendments which would have, in part, provided for these distinctions. In response to that, the UK government entered into a consultation process, which I believe finished at the end of last summer, and the government, UK government, currently has those findings, but has not published them, looking at whether or not there is, legal steps that could be taken to provide further legal protections. And indeed, there is also a private member's bill which is being introduced in Westminster, which would have a similar effect to mine. It likewise has a statutory aggravation that would apply to offences against retail workers in these situations. So I don't believe that there are any specific legal protections that retail workers have in other parts of the UK, but this very much is an issue that is apparent and is being discussed in other parliaments in the United Kingdom. Kenny, I don't know if you've got any other sort of particular legal clarification you could provide on what may exist elsewhere.
I don't have anything.
Right, I think I lost the end of that, but I think Kenny said he didn't have anything great to add to the bit I called. So on that basis, thank you very much. Dean, did you have anything else you wanted to ask?
Yes, please, Convener, and thank you to Daniel for that explanation of the protections available elsewhere in the UK. I wanted to follow up on a couple of issues discussed before about the different views as to the need for this legislation and what form the legislation should take if it goes ahead. For example, the need for the hindering and obstruction elements of the bill. I'd like to ask Daniel Johnson for his views on what elements of the bill could be stripped back from what is proposed currently without damaging the core protection trying to be achieved for retail workers.
Well, look, in my view, the most important element of this is the aggravation. Is the aggravation which I think reflects the seriousness of both the responsibility that we place on retail workers for upholding age restrictions and ensures that that's taken into account in sentencing and will give us a better picture as to what is the extent of this problem in terms of these crimes in society. By dint of that, having the statutory offence is important because it enables the statutory obligation, and for the reasons that we set out earlier, having that clear statutory offence, I think is important and useful in terms of the precision that it affords. And the other element of the statutory offence is that also provides the clear communication point that we provide. And then finally, the point around hindering and obstructing is important, I believe, but it's probably the least important element of the three key provisions. I think it's important because I think it potentially provides for an earlier threshold at which these situations could be nipped in the bud. As I illustrated earlier, there is quite a common scenario that takes place where things start out as one thing and then escalate to another. And that is an attempt to do that. However, as I said earlier, I recognise the potential problems. I also recognise the very valid discussion about the comparability of those provisions with the precedents that it's drawn from. So therefore, I think it is probably the least important element of it. So hopefully that provides some clarity for the member.
It does.
Okay.
Thank you very much. Convener, that's all I had. Thank you.
Thank you, Dean. Right, I'm going to move back to Andy Whiteman, who'd like to raise some questions and points of clarification. Andy Whiteman, please.
Thanks very much, Convener. Just following on from Dean Lockhart's question there. You implied that the statutory aggravation was, one of your principal concerns, and in your opening remarks, you made quite a lot of play of that. So it almost sounds as if you've created the offences in order to be able to have a statutory aggravation, and we covered the question as to whether you could apply that statutory aggravation to existing offences. I don't want to look at that. But of course, by doing it through a statutory aggravation to offences that you create in the bill, an alternative approach would be to create a statutory offence of obstructing and hindering a retail worker in the course of upholding age restrictions. That would be a clear alternative. I just wondered your response to that.
I think that is an interesting approach, and one that I think that could be examined. The reality is that when we were looking at this, we had a range of different possibilities for each of the different elements, and we picked what we felt gave us the sort of the greatest precision and greatest clarity. I wouldn't say that the creating the statutory offence is purely to enable the aggravation. It's that's part of it. I think the point of clarity and communication is an important one, and I think it's also about reflecting in law, and indeed it in a sense it borrows the from the logic of both the Emergency Workers Act and Section 90 of the Police and Fire Reform Act. But I mean, I think the approach you outlined in terms of creating that specific offence in terms of hindering, obstructing in relation to age-restricted items is an interesting one, and one. I mean, there which may or may not be possible to look at through stages 2 and 3 of this of the passage of the bill, if Parliament chooses to go down that route.
Okay, thanks very much. And if you could just clarify as well, I mean, one of the criticisms of the approach you've adopted is that if prosecutors were to choose to prosecute someone who had abused or a retail worker under the common law or for example, the Criminal Justice and Licensing Scotland Act, the statutory aggravation wouldn't be available in those circumstances. So if the statutory aggravation is important, it may be, given the statistics that we have on the use of the emergency workers statutory offences, may be that most prosecutions are taken under other laws, and one of your key objectives, statutory aggravation, would not be available in those circumstances.
Yeah. I may just bring Andrew or Kenny in terms of the strict technical elements of that. But I mean, I think what I would say is that there's lots of instances in the law where there are overlaps or even duplications between different statutes. I mean, I think what is clear is that, and again, if you look at the emergency workers with around, and I believe there was just under 200 prosecutions in 2017-18 under that, it is used. That is clear. It has very comparable penalties. I don't think there's any reason to believe that prosecutors wouldn't use this legislation if it was enacted. Does that mean that the numbers that are drawn from that are comprehensive? Clearly not. I would doubt that the 190 offences committed in 2017-18 is the totality of all the offences that were committed against emergency workers in that period either. This isn't about statistical accuracy, but it is about providing options. The numbers provide insight rather than precision in terms of the total number. But Andrew, I don't know if you've got anything to add to what I've just said.
Yes, briefly. I think the way you characterised it, Mr. Whiteman, may slightly get things the wrong way around. Obviously, I'm not personally an expert in criminal law. I've certainly never been a prosecutor, but my general understanding is that when prosecutors are deciding how to charge a particular offence, they very often do have choices. In this particular case, as we acknowledge, there's an overlap between the new offence created by the bill and existing common law and statutory offences. But I think my understanding is that prosecutors will generally favour a specific statutory offence rather than a very general offence, whether that's common law or statute, where they have the choice. So I think if this was passed, then the Section 1 offence under the bill would become the default option for prosecuting offences of this nature. And it's not so much a question that if they chose a different one, then the aggravation wouldn't be available. I think the fact that the aggravation would be available for the Section 1 offence becomes an additional reason why they would choose that one. So obviously there is still a small limitation, and as we've acknowledged, if it's a particularly serious case where they think that it would need to be prosecuted under solemn procedure, then they always have that option, but that would be very much at the top end of the scale. So I think that's the way round I would look at it, that the aggravation being there, certainly in a case obviously where this is about age-restricted sales and so forth, that is an additional reason choose to prosecute under the new offence.
Okay, thanks. That's very, very helpful indeed. Thank you. I've got one final question, and I mean, time is tight, and you may be helpful for you. Indeed, it may be helpful for us if you were to write to the committee in fairly short order to elaborate your response on this, because it is a bit complicated. And what I'm talking about here is the Scottish Government's memorandum, where they look at the Criminal Justice and Licensing Scotland Act 2010. They look at the three elements that are necessary for an offence to be created there. They point out that your offence, for example, of abusing a retail worker, could be committed by conduct that's not likely to cause a reasonable person to suffer fear and alarm, something that's required by the Section 38 defence there. They also point out that there's no reasonableness defence in your new offence, again, which contrasts with Section 38. Now, 2 or 3 minute answer is probably not the best means of articulating your response to that challenge, which they set out in quite some detail in their memorandum, which of course is published on the Economic Committee's website. But maybe you could have a brief response to that.
Look, I will take you up on that suggestion of writing to the committee, but the simple and short answer is both around intent and indeed kind of effect. In order to have a threat or abuse, you have to have the intent of causing fear or alarm, and I think that whether or not that is ever reasonable to do, regardless of what the circumstances, I think is questionable, and that sort of boils down to kind of what are you effectively saying, and there is a sense in which it could be argued that you're saying two wrongs can make a right, and I think in a sense that there's a potentially a problem here where they're saying because these are lesser order offences that it can't be reasonable to respond to one offence with another offence, and I'm not convinced, and it does, as I say, in the end I think come down to that point of intent. Kenny, I don't know if you've got any other sort of brief additions in terms of those precise points that the government have raised.
Mr. Tetkin.
Yeah. Yes, just on the point of the reasonable defence first. That was something we considered. Obviously, we knew that was elsewhere in legislation that threatening or abusing is without reasonable defence. However, when we were considering this, we couldn't really think of a situation ever been intended to threaten or abuse a retail worker, which is why we decided to reasonable defence. On the second point about the reasonable person, we weren't too sure what that would add to the specific circumstances of our provision. We do have other situations in which a reasonable person test isn't adopted in law.
Mr. Tetkin, I think we're having a few problems hearing you.
I think we can cover these points in correspondence. But I think the final point I would add is if a reasonable defence is thought to be necessary, it would be very easy to add that through amendments at stage 2 and stage 3.
Thank you. Yes, no, I think it would be useful for the committee to have a very clear exposition from you in response to what is quite a detailed critique or objection from the Scottish Government. That would assist hugely with our scrutiny. Thank you.
Okay. Thank you very much, Mr. Wakeman. And I think I would echo that as well. And I think that would apply to anything that you feel during this discussion that you might want to elaborate on. We have reached the end of our questions. I just wanted to raise one small point, Mr. Johnson, and that is that throughout all of this, what has become absolutely clear is that it is the fear is often instilled in shop workers when somebody behaves in a threatening manner. It might be somebody local that returns to that shop on a routine basis, and therefore it's often the psychological damage, not a physical assault, that shop workers experience. But we have heard throughout that it is about response, so it's whether somebody is called. And you made the comment that, if nothing else, a sign at the till saying it's an offence to assault or intimidate or harass a retail worker would be helpful. Can I ask, why is that sort of sign not up already? Because although there isn't a specific offence, it is indeed still an offence to do those things. And I wonder if retail workers generally shouldn't put those signs up at the moment.
Well, let me deal with both of those points, because I think they're both really important. I mean, I think they could. I think it's about the clarity of saying that it's under the Protection of Workers Act, it is an offence, and it has that precision and clarity. Whereas saying common law offence, I mean, you're starting to get into the realms of legal terminology, but potentially they could and potentially should. But I think that what this would do is send a much clearer sign and be a much clearer signal. But I think it's not just about that. There's also the other associated elements, such as the aggravation that the bill would provide. But finally, and I think that the point you start on there is, I think, perhaps the most important one, is that the crimes committed against retail workers are different, in part because of the legal obligations that we place upon them, but in part also because that when you're committing a crime against someone when they're at work, when they're carrying out their legal duties, what you're doing is victimizing that person in a place that they have to return to. When you're abused or assaulted at work, you have to go back to work the next day. That is extremely traumatic. And I think that is the point that I think needs to be taken much more seriously by us all, and hopefully my bill enables us to address in Parliament.
Thank you very much, Daniel. Is there anything you want to add before we close this session?
No, I mean, just simply to reiterate my thanks to the committee. I really do appreciate the time you're taking, and I would just like to add a little word of thanks to both Andrew and Kenny and the other members of the Non-Governmental Bills Unit. I think we are extremely lucky in the Scottish Parliament to have the system of members' bills, which means that we have this resource available to us in a much more straightforward manner than other parliamentarians do, and I am really thankful to them for all their efforts.
Yes, thank you, Daniel, and I'll probably echo that. Can I thank you for coming this morning and taking part, and also to your officials, Andrew Milne, and Kenny Tetkin. Kenny, I'm sorry we didn't have very good communication with you. We have found it difficult to hear you this morning, so I'd get onto your broadband supplier. On behalf of the committee, I want to thank everyone that has contributed to the evidence sessions on this bill. It has been quite comprehensive, and we will be now considering our report, and hopefully it will reflect what we've heard over the last few weeks. I also want to just take this opportunity as well, on behalf of the committee, to thank all our retail workers who, without a doubt, this has been a very unusual time, and it's a difficult time. And I think retail workers particularly have had to step up to the plate. They've coped very well, and they've continued to deliver what is an essential service to all of us. We hope that we will do them justice in our consideration of this private members' bill that has been brought forward. So that does conclude this morning's public meeting. And as agreed at the beginning of the meeting, I'm now going to move the meeting into private session. So I'll suspend the meeting for 10 minutes for a comfort break. Thank you very much for tuning in.